Good evening, everybody. Welcome to today's show. To start today's show, the first thing is best wishes of World IP Day. We are celebrating World IP Day today, and this program is brought to you by DPIIT IPR Chair, NALSAR University, and NC Banerjee Center of IPR Studies. So, World IP Day is being celebrated from the year 2000. And April 26th was identified as the day because that's the day when the WIPO convention was came into existence. To celebrate the WIPO World Intellectual Property Formation, April 26th has been identified or as the World IP Day. Now, World IP Day every year comes with a theme. It The reason why we celebrate is to highlight how creativity, innovation, and other uh, sensitization of awareness of IP is brought about. This year's theme happens to be IP and music. Find the beat of IP. Now, music is something which has touched the life of most of us. It is something which invites us to dance to the lyrics and the echo of our emotions. So the expression of music plays a pivotal role in our life in a vibrant and a diverse manner. So today we are going to look into the intellectual property rights which are associated with it. And as we are moving, music is evolving faster than ever. And intellectual property is also struggling to keep pace with the advancement in the music domain, from copyright battles to sampling conflicts to AI generated music, so on and so forth. To have this discussion, we have a very uh, important person to join us. Please welcome Mr. Ayan Roy Chaudhary. Ayan presently works as a head of legal and compliance in the Broadcast Audience Research Council, BARC. He has been both in litigation and non-litigation for over 2 decades. Some of his prior corporate engagements include, vice president in Saregama. He was director legal in Sony Pictures. He was, general counsel in Balaji Telefilms, and AVP legal in Sony Television, and also smaller stints in Accenture, Reliance Entertainment, and National Securities Depository. Additionally, he has been associated with Queen Mary's Intellectual Property Research Center at London as the Herschel Smith Research Scholar, and also with Max Planck Germany. And with this brief introduction, I would like to welcome Mr. Ayan Roy Chaudhary and request him to, on this auspicious occasion of World IP Day, to give his opening remarks.
Thank you, Dr. Sharkar, for this invitation and for having me in this podcast for expressing my views on the issues around IP and music. To be interviewed by somebody as eminent as you in the field of IP is in itself an honor. And I thank you, both yourself and NALSAR University, for this opportunity. So I am ready for all the questions that you have. But I must tell you that music, last year I was at GNLU for this Sustainable Goals Development. And rightly so that the music has been chosen, because music is one of the fastest growing elements in the family of copyrights. It is one of the most fastest growing sector revenue wise, and that is the reason WIPO has correctly chosen it to be the theme for this year. So very exciting times that we are in. Yeah, I'm more than happy to take the questions that you pose with me and discuss. It is not just a question answer, but I believe it will be a discussion
Yeah,
around this issue.
it's more of a discussion.
Yeah.
So let's start with the very basics. So when
Mm.
we talk about the basics, and we talk about music, you know, for a common man or even a practitioner, if you can throw some light, what are the different types of IP that apply to music? And how is it critical or crucial to the music industry of today?
Mm. So look, when we talk of music, sorry, a lot of things comes into our mind. So let's first begin with the understanding of what a music is, or what we hear. What we hear is, in terms of IP. In terms of IP, it is called sound recording. The recording, basically. Now that itself is constitutes three different works in itself. One is the lyrics. Second is a musical composition. The third is the performance, if there is a vocal artist attached to that music. If it is just instrumental, then it is just the music, no lyrics, just the composition. So these are the three different elements. Under the law, all these three are individually protected as works, and sound recording is also protected as works. Um, to understand what is lyrics, now, in a given common parlance, lyrics can be termed as a poetry, but not all poems are lyrics. So there is a understanding of who are songwriters. So basically, lyrics are rhythmic, metrical expressions, which are in meters, basically, in a verse form, and that can be performed as a song, as something lyrical, or as something, in a rhythmic manner. That is what the lyrics is, and that is the reason songwriters are treated a bit differently than the poem writers. But in the world of copyright, both are literary works, and it is clubbed under the literary works only. But in a practical world, when it comes to organizations managing these rights, songwriters have a different organization to manage their rights. Musical composition, as we all understand, is the composition, like the sheet music or the notations that comes. Those are the compositions. In earlier times, it used to be handwritten, then it was machine driven. Today, it is composed, and then the sheets are coming out. And of course, the most important part, if it is a vocal performance, then the artist or artists performing and recording their voice in that sound recording. So that is, this whole thing is basically a music composition, or a stem, or a sound recording combined into all of this. And how critical, I mean, impact in the entire issue of entertainment. Music is increasing. The global revenue around music has only increased over the years. It has increased tremendously. Um, so right now, the entire, as per the latest reports of the IMI, it is in billions, 1.6 billion, or more than that, I believe. The entire 2023, I'm saying wrong, 28, around 28 or 30 billion worth industry is the entire global music industry. And it is used in various forms in the entertainment domain, in various aspects. So the one single definition of why music is important, um, music is there in all aspects of our life, and because it is there in all aspects of our life, it requires the copyright laws around it to protect it, to monetize it, to optimize its utilization in the various old formats as well as the new formats, as we go on discussing in this discussion. Yeah. So I believe I have been able to answer your query.
That was wonderful. You explained it in such a lucid language that and I think that's we have a good start. But if I look at today's world of music, today's world of music is also dominated by remixes and and DJ sets. So, do all remixes DJ sets require permissions, or what is the legal landscape around that in such remixes or even sampling covers? What's the situation in that area?
Before I answer that question, before I delve into answering that question, going back to the older question as what are the IPs involved in music? What I told you is about the sound recording, okay? But apart from sound recording, there are few other things that are there in the music industry also. One is the trademarks, the logos around the music companies. Now, earlier, these logos were used for marketing purposes, and this is also relevant for remixes and all these things. Let me, try to string the answers in that fashion. So, trademarks were earlier used for merchandise, marketing, selling goods, selling the records and CDs, etc. But in the digital world, these trademarks have become very important for content identification in the digital world, number one, and watermarking, and also to track infringements. So, any video with a inbuilt watermark of the label cannot be used or can be easily tracked if it is infringed. That is the benefit of having trademarks in the contents, in the music contents for the music labels. The another aspect, another IP involved in the world of music is your world, which is the patent world, basically. Patents are also there in the music technology. So we have all heard of, the basically, Edison's version of what you call as the phonogram, which he had used. But gramophone, which was a later developed, and it was basically a improvement over the existing thing that Edison had phonogram that Edison had invented in 1877. Now this gramophone, what was it? It was that if you remember the earlier records, which had this one single string, one single hand arm, which would be played on those revolving discs so that the sound can generate. That was the invention. That is all. These are all part of the music inventions. Later on, today's world, machine learning inventions are also patented as part of the music industry patents. Spotify has done it. Spotify is one of the leading, music platforms. They have done it. And similar, like for example, the Metallica, they use a lot of these electric guitars. These are all patented, instruments. So the world of music not only has copyright in it, it also has trademark and it also has patents. Now coming back to your question of the remixes, covers, and sampling. Let me split it into three different things because these are all three different elements. Sampling is basically using small portions of an existing sound recording, which is existing recorded song, in any advertisement as a sync or in any small music, something you are doing and part of it you are using it a small thing. Mostly it is used in advertisements, but also in some other music that you are creating, you use a portion of that thing as part of your other recording. That is sampling. For that, you have to take license from the labels because you are using the sound recording. Do you have to take license from the IPRS? Now, before I delve into this question, I'm moving on with this presumption that we have to deal with basics. What are the rights involved? So we have understood that there are three different categories of works, but there are rights involved which needs an explanation. One is a public performance right. Now, what is a performance right or a public performance right? The differences. Whenever the literary work, the musical work is getting played out in public, that requires a license. That is one right, but that is an element of the literary and the musical work. That is not an element of the sound recording. Sound recording again has a separate license to be taken for its performance to be made available to the public or being available to the public. When you're doing sampling, you are taking a portion of the sound recording. So you have to take license from the sound recording companies. That is one part of it. The second part of it is what you cover as covers. Covers is a bit different. Covers are basically, there is an existing song, say suppose existing Lata Mangeshkar song is there or Kishore Kumar song is there. You want to create a cover of it, which means what? Which means you are going to take away the singer, the vocal artist's performance, and you yourself or some other new artist is going to record it in his own voice. So what are you using there? You are still using the lyrics. You are still using the composition. What you are not using is the sound recording. So a license from the IPRS is still required because you are using the lyrics. And IPRS is required because although these rights are there with the music companies, but they generally assign it for the sake of collection of the revenues to these collective management organizations called CMO, and they are responsible for collection of the royalties, etc. So you have to still take a royalty license from them. That is cover. Now comes the remixes. Now what is remixes? So the remixes and samples and these DJ sets are same or in the same family, you can say. They're brothers and sisters. They are also using different musics, different sound recording to create a new set of sound recording. Again, a license from a sound recording company becomes absolutely essential. Now, DJ sets are a bit different from remixes, though they are in the same family. They're a bit different because what they will do is, you remember the earlier records, the long playing records. Those records earlier were used by the disc jockeys to mix and give a feeling. Say, suppose somebody is there in the marriage festival, marriage ceremony. In that ceremony, they will mix the various marriage related and similar songs to create a different experience. If you are in a festival, they will do something towards the festival songs. Garba is one of you know this Garba, and all these festivals are famous for these remixes. And DJ sets are a bit different. They come with they do these remixes. Earlier they used to do it with using these disc jockeys. Now, because those discs were used, they have got replaced now with basically by the softwares. The softwares are used for by the DJs to mix and remix the songs in a given environment. To answer your question whether permissions are required, all of this, if it is taken without permission, is an infringement. Now, the obvious question will arise: if I am using bits and pieces, then is it an infringement? So, and there is a principle in copyright called de minimis, or something very trivial that is getting used. Now, in the analog world, and I have done these cases where I was very successful in the analog world, using a portion of a dialogue in a film, and the film producer, the original film producer, and the writer sues established studio. I can't name all these things, but established studio for blocking it, and the court rules against that person, saying this is just a small portion of this which has been used in the film. That was the world of analogs. That was when the digital was still not very much in the play. But in the digital world, it is A, ubiquitous, B, it it doesn't go off the shelf. It is there in the shelf. So the entire principle of de minimis, I would say, and globally this has happened, this has got reduced. So the argument against infringement using de minimis is not maintainable anymore. In all the three instances that you cited, so particularly sampling and DJ sets, one may try doing it, but it's better not to do it. And in the case of DJ sets and in all these festivities and all these ceremonies, etc., of course, marriage ceremonies are excluded out of it. Religious ceremonies are excluded as per the exceptions. But wherever there is a commercial activity, commercially driven festivities are there, there the venue owner or the event, the person organizing the event needs to have a license. So, for example, today if we are doing this, and I'm trying to, of course, this is an institution or an educational institution, it is barred. But if it was a ticketed event, if there was a commercial element to it, we are somewhere in between. We don't know, because many of these webinars are also paid webinars, right? It is not always just instructional. So we really don't have any case law right now whether educational institutions holding these kind of events, and if they are playing music, even if samples, even if small pieces of it as part of educational instructions, but receiving money for these kind of courses, whether it will be infringement or whether it will fall under the exception, the educational exception, research exception. We don't.
If I organize or take part in a flash mob, what should I be careful about?
If you participate.
No, suppose I organize a flash mob today at a
You have to
certain.
be careful. Yes,
I
of
have to be
course.
careful about all this.
Yes, of course. Even in corporate in-house events, say suppose a corporate is arranging a annual function, right, in a hotel, right? In that also, if the hotels doesn't have, because some of the hotels may not have these kind of permissions, the organization, corporate organization which is arranging the annual function needs to have the permission.
No,
Because look, the thing
in my
is that
part-
if you don't have the permission, it is not as if tomorrow you will be held liable unless they come to know. How will the right owners come to know? That is a bigger question. Many times these, the event managers or our own corporate people, they might say, "Arey, kahan se pata chalega inko?" How will they come to know about this?
that's very simple today.
Yeah.
Because we are most of the people in today's world are under a severe pressure of social media.
Yes. Yes.
So they
Correct.
themselves will be telling the world that this happened.
Yes.
In fact, in my corporate life, I have received such legal notices more than once for flash mobs, or or some of the movies being screened at in-house program from leading film producers of our country. So, and how they come to know is very easy, because we will like to take selfies and
Yes.
photographs
Yes.
and immediately upload it.
Yeah.
So
Yeah.
we are ourselves giving them. And anyway, what's wrong is wrong. Whether you upload or don't upload is not a matter of fact. Now, moving forward, as an independent artist, or a label or a producer, what is his right? And does any does the societies or organizations influence that?
No, so the thing is simple. Okay. So today I sing a song. Okay, I record it using my own. I know how to play piano. I record a song using my own tape recorder, whatever recording device. What are the rights? I have right as a vocal artist. I have right, and I have also written the song. So I'm a lyricist also. I have right as a author of that lyrics. I have right as the author or the music composer of that music composition. And how do I exploit? I can just simply put it up on the YouTube, and YouTube, if it gets lot of links, views, and basis that view, if there's a lot of ad revenue which is it attracts, because how YouTube works is it is based on the clicks or the views. There is a mechanism which they use basically, that if a view is more than what is the duration of the view. If the view is less than 30 seconds, then it is not considered good enough for advertisement. And you would have noticed this. Now today, when you are seeing anything on YouTube, you will get interrupted by advertisements. So if you are watching any content on YouTube which is more than 20 seconds or 25 seconds, you will certainly get a advertisement coming on your way, which means that the AI, built-in AI there, has recognized that you are watching it for more than 20 seconds, and whatever revenue attached to that advertisement will be given to the person who owns the content. So if I'm an independent content creator, I have all the rights in the world to put it up myself. Now the question of whether I can give it to the organizations or not. So as I said, or even if I didn't say, each work needs to have a separate copyright society for managing the rights of the independent artists. They have the rights. It's not as if they don't have the rights. Now there are two questions to it. Do they have the rights even after they have given it to the producer in case of a film music? Do they have the right even after they have given up their rights to a CMO? It is all depends on what does that contract say. Now, in case of films, in case of film music, and that is where the entire debate happened before the 2012 amendments, and starting from 1977 judgment of the Supreme Court, that who's the owner of that lyrics and the composition? Is the film producer owner of it, or author? To we understand the person who has written, he is the author, and but who is the owner? In the 77 judgment of AIR of the Supreme Court, it was very clear that the producer at whose instance the entire film was being produced, and who made it possible for the writing to happen and the music to be composed and then included in the film, continues to be the owner of it. Now, when he becomes the owner, obviously that is the reason producer licenses it to a music label. Then music label in turn reuses number of times on different platforms. Earlier it was the long discs, then it came the cassettes, then CDs, then digital. Now AI driven things, now these OTT platforms, the and net platforms, all these are various avenues of revenue. Now the revenue which comes to the music label. If they have done a all over purchase, it is retained by music label. If they have a royalty share arrangement, they share it with the producers. Where is the writer, the creator of it? That was the most pertinent question during the 2012 amendments. And this entire thing was led by Mr. Javed Akhtar and the other people in the music industry. So what happened is that in 2012, it was decided, and that is how the rights or the language was made in the law, that even if the assignment is given to the producers and eventually to the music labels, the authors of these works will remain entitled to a royalty every time the work is performed publicly. That is, it is consumed in the public space, other than cinema halls, because that was the Supreme Court judgment, 77 judgment, that if it is in cinema halls, then producer is the sole owner, because that was that was the claim that time of IPRS, that why should we not get a revenue share from the ticket sales of the theatrical exhibition when a song is getting played there. So Supreme Court said, no, you are not, because producer has paid everything. You have already been paid. You are not entitled to. Over the years, the platform 77 till now, the different avenues of the revenue has multiplied or increased or has developed. And that is the reason the judgment, the amendment was that any platform other than theaters, if it is played, the author shall be entitled to a royalty. That royalty will be determined by the collective societies. If the writer has not given away his rights, he can demand it, right? And the biggest question is, who is liable to pay? Is the producer liable to pay? Is the music label liable to pay? Now, that is $1 million question, and I must tell you that amendment was challenged by television broadcasters at that time, and it remains unsolved before the Supreme Court. The question was, right now what is happening is there are agreements which are entered by these broadcasters with IPRS, with the collecting societies, but not at a rate, not at a basis a rate chart. It is one-to-one agreements which are entered into. Okay. So yes, the independent artists, producers, they are all entitled to the royalties in today's world. And I must say, this is a unique legislation. In all other countries, it is more of a trade negotiation which happens. It is more of a trade arrangement between the various CMOs, that you will charge this much, I will charge this much. In India, because probably the government of that time realized that, you can't really trust the and there was an issue. There was an issue with some of these one of these CMOs at least, and that is the reason you can't trust maybe, and that is the reason it was made a statutory right for the authors of the works who can collect the royalties every time it is getting played or performed in public.
Oh, that's wonderful, wonderful to know. But as we are changing with time, nowadays, we are more on streaming, the digital world. So, like this program, also we are streaming. So, in the digital world, where most of the time streaming has become a part and parcel, uh, to spread performance in different corners. So, do you see that musicians are actually monetizing through this streaming process, or it's only live performances, or there are sync deals, and how the musician really making money out of the IP, which is the right which they have got, and do PROs or the new models like Web3, NFTs, smart contracts playing a role in this?
Yes, all of this is playing a very definitive role. So, but I must say these are all contract driven, and it is all dependent on the contracts which are entered. Some of the leading platforms, like for example Spotify, pay a per stream basis. So every time a particular song is getting streamed, a particular revenue, a particular amount of royalty is shared with the artists. Same holds for Savan, the Geo Savan platform, and same holds for the subscription-driven platform. These are all subscription-driven platforms, unlike YouTube, which is ad-driven platform. Of course, they also have a subscription paid per version
Which is that free?
section, yeah, which is also there, but mostly it is ad driven. So yes, the new technologies, like say for example the NFTs, are also being used to sell the content or sell the music, and it is this entire thing right now is only going to increase. In India itself, the streaming, the revenue in 2022 reports is around 2,000 crores. So, but who is making it? Are musicians making it? That is paid to these CMOs. CMOs then distribute it to the authors, distributed to the stakeholders of their respective CMOs. For example, ISRA was there, which was basically for the vocal Singers Rights Association. On the insistence of the government, I believe, to the best of my knowledge, the musicians, the background score musicians, were also included in it, and rightly so. So, if you see a guitarist or a tabla player, they are also in. If you, the entire, they are also performers, right? They are also performing. Their music is also getting performed, so they also should be entitled to a part of the royalty which ISRMA receives from the exploitation of any of the music that was done. And there are internal arrangements between the IPRS and ISRA, basis which royalties are divided in certain manner. Some of these are public documents, some of them are not, because these are contractual arrangements. There are agreements between, and of course, this is what I'm saying is within India. Now, there are international also collaborations, like PRS in UK has a collaboration with IPRS in India, that every time Indian music is played there, IPRS can have a claim from PRS to collect revenue, collect royalties on behalf of the songwriters and the composers and the sound recording companies from there. In all this, there is another element, which is the public performances of the sound recordings, which there are different organizations for that, and these organizations either basis their licenses, assignment agreements collect the royalties, or because they are registered as a copyright society, they are entitled to collect the royalties. And there's a lot of, I must say that interpretation wise, a lot of disputing decisions have come from Madras High Court versus Bombay High Court versus Delhi High Court, right? Recently. So those are there. But yes, to answer your query very squarely, the new models are also paying the royalties. They are also generating royalties, particularly the new blockchain-based contracts are ensuring, the automation of the royalty payments or distribution. One of them is WazirX. We know that they sell NFTs of the sound recordings. Then another thing which is a very new development is that today you may not require. Earlier, what used to happen is that if it is not a Bollywood music, and if it was you're an individual singer, you have to be one established, etc. Then you have to have an AR, artist management repertoire arrangement with the music labels. They will manage your rights, etc., etc. This intermediary has been taken over by software platforms, and Raftar, for example, is one such a platform which issues NFTs and then collect revenues, and then also gives it to you, whoever the individual artist is. So you really don't require a label as such, like what you used to do earlier. So that is also happening. And smart contracts, of course, that is the way to go. They allow easy asset allocation and easy distribution of the royalties. But for the smart contracts to operate, one very important element is there, which is the contracts or the rights have to be clearly understood from existing contracts. Now, that is very easy thing to do when it comes to music of our recent times, particularly music post, you can say 2000. But the old music, at least in India, may not have that clear, you know, clarification as to who owns what rights, because either those musics don't have complete agreements, or those music or the wordings of those contracts may not be very clear. So unless music labels come out clearly and they say um, what is their position, um, it is, I mean, the scene is pretty not very clear as for the operation of the smart contracts in those cases. But modern agreements, yes, it can operate very clearly. It can operate, and it is operating right now.
That's quite a big of relief that, at least we are moving where we can articulate proper language and have a control. But having said that, once we talk about streaming, today's music industry, uh, it's not only auto tuning. Okay, the auto tune is an old thing. Today it is AI has entered everybody's life, including it has not spared the music industry also. So we are getting quite a bit of AI generated music, okay, where some of the not only copyright, other forms of IPs are also questioned. And so, what is the impact it has made to commercial music and films? The use of AI. Having seen that, where A.R. Rahman is suing somebody for using his themes for falsification, or what he calls using AI, or Ilayaraja is getting sued. So, what is the real impact that really this AI is making as of now on commercial music and films?
Two separate things. I won't mix films with this because films is a different domain and there's a different fight
Because
altogether in that part. I'm saying film music, if you may.
yeah,
Um,
film and commercial music I'm talking
yeah,
about.
film music and commercial music, or any music for that matter. Lot of issues. If in the world driven by AI, there are a lot of issues which are happening. And so, look, the three things. One are these new frontier technologies, what WIPO calls as the new frontier technologies. There are three major new frontier technologies which are in front of us, which are the evolving technologies, which are the technologies which are taking shape as in front of us, just like how internet took shape in front of us. One is AI, one is blockchain, one is metaverse. Each of this have their different effects and reactions in the world of entertainment. Now, coming to AI, we saw how blockchain is actually helping. The smart contracts are helping as far as the identification of content is concerned, as far as the tracking of the royalties are concerned, as far as the rights management is concerned. That is a very positive side of the evolving technologies, particularly the blockchain. Um, when it comes to AI, there are multiple questions on table right now. And as we speak, there are some 39 cases which are pending on these questions of copyright versus AI in the US courts. Some of them have been answered in their interim orders. Some of them are getting answered. Now, the principal question is, what are the, not question is not, I would say, what are the principal questions rather? One is, of course, the authorship versus ownership debate. Who is the author of AI generated work? When I say AI generated work, AI using existing database of music works from as available in the internet to create music of its own. Suno is one such platform which has already been sued, and whether it can use whether it can firstly train their AI models basis existing works. That is the question. And what about the output? That is the input part. What about the output part? Is the output part which is coming out today is entitled for copyright ownership, authorship? Because human element is the most important part of any intellectual property work. And if that human element is absent, can it be given the the authorship, and to whom should it be given? The owner of the platform, the company which owns the platform, which has funded the platform? There are no clear answers to it. And but one example which I can draw is that if we go down to the very basics of it, I am used to writing something. So I have written something using pen and paper. The company which owns the pen or which owns the paper doesn't become owner of the content that I have written using pen and paper, right? Then came typewriters. Typewriter company never became a owner of what is typed on the sheet, right? Then came computers. So computer came with softwares. What we type in Word, Word is not the owner, or Microsoft is not the owner of it, or any such software is not the owner, nor is the machine owner of it. I continue to be the owner. So AI is just a tool. AI works in coordination, at least the AI which has evolved till now. They work on prompts. They are or can be used or are being used as tools by humans to create content. Earlier, instead of writing or typing, I have to type it on a computer software. Then came machine learning, which can type few words, knowing what can that word be going forward in our small prompts, searches, etc. That expanded into what you call as AI driven content, and that content can really create something if I give them a prompt. So if I give a prompt that write a poem like how Dr. Sarkar writes a poem, it might come out with some sort of a literature. Now that is, so the question of whether AI will ever own the copyright of something is, I don't think is feasible. I already answered by US Copyright Office that if human element is absent, then it cannot be treated. Then the question is, human assisted or prompted content, who is the owner? Of course, the person who is creating that content should be the owner. Now that is where it is very easy. The problem is, because AI is based on things which are available in the world of internet, the chances of me giving a prompt and you giving a prompt, or anybody giving a prompt, like an individual to the power of n giving prompts, and the output coming out of it, and the similarity of the output coming out of it is very high. So if I say, for example, write a poem like, say, like any of the old authors, like say Shakespeare or Tagore or any of the old authors, or Wordsworth, they will write a poem for me on nature. You sitting somewhere else giving the same prompt might also get the same answer. Then who owns the copyright? So what is the solution around AI-driven outputs? Now that is as far as the literary part of it is concerned, or the musical or the lyrics part of it is concerned. Compositions may have a similar problem. Same compositions coming out from different. So say, for example, Beethoven composition is in the public domain. Anyway, public domain. If everybody starts to say that draw me a music piece based on sonnets, we might actually have similar pieces of compositions coming out, though human element is there. And in that case, who will own? Should even copyright be given to this? Because one element of copyright is originality. Coming to the question of originality, is the output which is coming out from a human brain, is it always absolutely a new thing? It has to be a new expression. It can't be a copy. It is influenced by a person's experiences, but not always. I give you an example, and being Bengali, I'm driven to a lot of Bengali works and all. There's a very good Bengali song of Manade, which is Coffee House Er Shei Addata. that song, and I was not aware of it. The history, I came to aware of it through one of the clips that I saw, and it is the son of the author, the lyric writer. He's saying all these things, that neither the lyricist nor the composer nor the performer, that is Mr. Manade himself, they have never visited copyright in their life. Then how is it that such a beautiful song came out of the song? We know it's quite a popular song in the Bengali song thing. So that is the thing. So we really don't know. Now the other part is,
Probably
what about,
because the life in coffee house is very iconic.
yeah, very iconic, yes. And
Yeah,
imagine people
all
who,
celebrities used to visit there, so it's very iconic. And when somebody says Addata Aja Nahi, Addata Sutti Aja Nahi.
no, well, but that is a very subjective thing. I recently was there and I found it, well, nostalgic, for certainly pretty nostalgic. But the point is that the people who created it never visited that place. So humans not having experiences, writing something, is it improbability? No, not certainly not. They can still be writing a lot of things. Um, uh, but AI, what does it do? It has a larger data set available with itself to create something prompted by a human being. That is what AI is doing today, or creating some content or creating this thing. Now, there's another very important issue out here, is the synthetic voice, which these music, platforms, the AI-driven platforms, are also doing. Synthetic voice, as far as of living artists, of course, artists like Arijit and few others, they have trademarked their voices so that nobody can copy it. Copyright is not available for, it is available for the performance which is recorded, you see. It is not available for the voice. So tomorrow, for example, a label can use the voice of, without taking the consent of the artist, and use it for a different composition or to sing a different lyrics. Now that is good. That cannot be done. There are personality rights issues. Trademark, these things have been trademarked, and living artists can certainly file a case and prevent these kind of misuses, inappropriations. What is more intriguing is, what if these labels start using synthetic voices of dead artists, say Lata Mangeshkar, say Kishore Kumar, say Hemant Kumar, Manna Dey, whoever. Can they use the synthetic voice? Are they entitled to use? Is there any legal bar? Now, one of the interim orders of Bombay High Court very clearly says that personality rights ends with the person's death. Of course, there is an element of moral rights in the copyright legislation, by using which the heirs of these dead artists might file a case, but we have to still see what will be the result of it. And that moral right is basically unending. It doesn't end with the term of the copyright. So one can file a moral rights case if such a thing has to happen. But that is another area that there is no legislation or there is no precedent right now. That what happens if somebody uses synthetic voice, somebody uses AI-driven voice to recreate some of the songs or some of the modern lyrics in the voice of old artists.
So going forward, what you are saying, this has actually resulted in quite a lot of virtual artists, or what we call deepfake vocals.
Yeah.
Do you suggest that we need a new legal framework to handle this?
Yes, I'm certain that this IP AI driven ecosystem, not just in India, it will require a global legislation to come up. Because while IPs are territorial in their approach, but in the world of internet, it has become available everywhere. It is ubiquitous. It is available to everyone. And this is getting again augmented in the world of AI. So there's no guarantee that a person sitting in, say, California or Timbuktu is using the software to recreate a Kishore Kumar song in today's lyrics. And who will file a case? Can his son file a case against this kind of a uses? Where will he file a case? Even if he files a case in India, the server might be somewhere else. The platform might be somewhere else. Can it be enforced? Okay, it can be enforced by blocking its availability in India. Just like how infringements, the copyright piracy used to be blocked. Maybe it can be blocked in India. So it is not just a territorial law is required. We will require a global law to regulate to some extent the AI driven ecosystem, AI IP driven ecosystem. And this will have effect not only in the world of music, you see, it will have effect in the world of music and all the other ancillary sectors around, entertainment, which are like gaming, certainly the animations, audiovisual certainly, and music, of course. So all these allied sectors or ancillary sectors also will require to be brought under this larger umbrella of a AI IP ecosystem regulation as to in terms of ownership of these things, in terms of monetization of these things, and also for the purpose of enforcement or prevention of any infringement around these things.
Having said that, when you just pointed out something on globalization, and if I want to take it forward, see, globalization is something where the penetration has happened in a very large way, because primarily because of a tech-driven industry which controls everything, including music. So, um, I mean, are there any differences you see between territories, or it can be an harmonized global situation? And where do you see it going forward?
No, so as I said, that look, the thing is that the laws today are territorial. IP laws are very territorial, and that is how it should be because it has to protect the authors, owners in their respective territories. But we are the world is increasingly connected, right? It is connected across our systems, and particularly the digital era, which is happening over a period of time, and it is increasing. So today, a person sitting in, TikTok is presently banned, but TikTok, like a lot of other softwares are there. Today's person sitting in a very who has internet connectivity, and we have internet connectivity, and that is increasing every day. Sitting in a very village in India, and some distant village in India, can use an existing sound recording with his video stream and upload it um, in the internet. And if it is successful, it might also get a lot of views. And imagine the owner of that track is not in India; he is somewhere else, in some other jurisdiction. For that infringement, to enforce that infringement, of course, it will go through the established IP IT laws, where they will try to claim ownership using content ID things. They will try to claim ownership over that content and any revenue generated out of it. But what if it is on social media? It is not necessarily on, say, like YouTube. It is not necessarily on Spotify. What if it is on, platforms like TikTok or social media? Now, these social media and all these things, they also enter into licenses with the record labels, right? But where does the individual artist go? Individual artist cannot possibly enforce its right. So they will have to compulsorily join an organization, CMO. These are all very open-ended questions. Where does it go? Where will it go? Where will it land up? Whether piracy is going to increase? Of course, there has been increase in the piracy of the content, of musical content, of audiovisual contents, of gaming content all over India. But that will remain as a challenge, I believe. The more the availability increases, the more the propensity of piracy will increase. As copyright owners, what owners can do, and we have been doing, is to contain piracy. Complete removal, stopping of it probably will not be possible. And even if we have a global act, there will be some nooks and corners of the world where, say, Europe, for example, some of the countries of East Europe or distant, which are not in the normal domains of the copyright treaties, they will be there, and people will be setting up their servers maybe there. Now, this is increased with the use of the cloud, servers. Whom will you approach to stop them? These remain open-ended questions. Not necessarily there are any answers right now. Answers will have to be basis copyright, basis contracts, and certainly basis technology. For example, one big example is, if there are these AI companies are there which are enabling a lot of content to be churned out basis their AI models, some regulation has to be maybe there, or something has to be there, that AI driven content has to be watermarked and cannot be otherwise used. Just how the devices that were the entire piracy thing was tackled to some extent using watermarking of the content. Maybe AI driven content, the output needs to be watermarked permanently so that it cannot be used as a copyrighted, cannot be used for anything which is again copyright, can be copyrighted or can be protected by copyright. It is AI driven, so it need not have a copyright protection, and it can be consumed by anybody and everybody. Maybe that is
basically in public domain.
Basically in the public domain. So if it is if it is watermarked as a AI driven thing, AI driven output, whether it's music or a literary work or artistic work or whatever it is, no copyright, and further works can be made out of it. Maybe none of it will be entitled for copyright protection, and then probably the market will decide, and that is where the open market will decide, the free market will decide whether I want to consume something which is AI driven, synthetic, or I want to consume something which is human driven. A full-fledged AI driven film has been released. Now let's understand one thing very clearly. When we consume any entertainment product, particularly music, and when we consume entertainment product like films, apart from the content itself, there are a lot of these cultural underpinnings, nostalgia, biases, preferences which are there, that cannot always be copied. You see, if I want to hear a certain Vedic chant in a certain voice, even if it is synthetic voice, I may not want to use it because my allegiance, my cultural allegiance is towards that, you see. Similarly, in audiovisual content, why is this fan following is there? Why do you think so much people still, in spite of all the availability of the things, they still go to IPL? They still, in spite of all this, ravaging heat, in spite of all, they still attend all these live concerts. Why do they do it? There is an allegiance to the artist. There is an allegiance to the performer. There is an allegiance to the performing those which is happening live or which is there. Similarly with audiovisuals, why do certain artists attract more footfalls versus the other artist? why they are more popular? Because this is that allegiance. Can an AI-driven output command that kind of allegiance? Can they create a new Shah Rukh Khan? Let's put it that way, or Amitabh Bachchan.
Probably not. So, I'm really, we are having a wonderful discussion, and you have actually made this conversation very lively by your lucid comments. But we also have a paucity of time. So, before we really end up, your final thoughts and key takeaways, a quick.
My final take is that we must keep our eyes and ears open. And one thing I must say is that we must be open for adaptations. What I have seen is that, look, the thing is that the technology uh, will march on. You cannot really regulate the technology, because that you can regulate, but the technological innovations will have to occur. They should occur. They should happen. In the name of regulation, we should not stifle the innovations. And all these are new innovation, new things which are happening technologically. They can't be and should not be stopped. But at the same time, um, we must adapt ourselves to those evolving technologies. The law must adapt itself to the evolving technologies. When YouTube came, before it was taken over by Google, YouTube would be the place for all the infringing contents. It still is. But look how the technology has evolved over a period of time. Firstly, it was taken by Google. Then the revenue streaming, the revenue share thing started. Then the content ID came, by which the contents can be identified and it can be monetized. So that is all I can say, that we will have to keep our options open, our this thing open, and regulations will follow. But we need a global approach. It can't be just territorial anymore. At the WIPO level, these things should start taking shape, and discussions which are already should start happening.
Thank you very much, Sean. With that, we would come to an end of today's streaming. I'm very, very thankful to Mr. Andra Chaudhary for sparing his time and thoughts, sharing his thought in such a lucid manner. I am also thankful to our Honorable Vice Chancellor and Registrar of NALSAR University of Law for his support and constant encouragement. Today's event was brought to you with the support of DPIIT IPR Chair, NALSAR, and NC Banerjee Center of IPR Studies. Thank you very much. We will be back with other programs very soon. And lastly, let me explain it once more. All the best wishes for World IP Day. Thank you very much. Have a wonderful evening.
Thank you. Thank you, sir.